Sanibonani, Dumelang, good evening and welcome to episode 226, 27 rather, of the Private Property Podcast. I'm your host, Uzamantungwa Khumalo. It's Thursday edition of the Private Property Podcast, and as many of our regular viewers know, as it is a Thursday, this evening later on the show, we're going to get to unveil who the lucky winner is of the 500 Rand spot prize that we have for our Sherlock Holmes competition. Now, if you're watching us for the first time, you're probably wondering what I'm talking about. Well, firstly, welcome to the show. It certainly is great to have you join us for the first time. Do make sure that you go to our Facebook or YouTube page to catch up on some of the great content that you have already missed out. Now, what I was talking about earlier, we're currently running an exciting competition across our social media pages that you can go onto and enter on our website on www.privateproperty.co.za. This is the Sherlock Holmes Hunt, where every single week we share a unique riddle that we want you to crack. And if you successfully crack it, you stand a chance of walking away with a 5,000 Rand voucher every single Friday. But because we also love making the winner's circle bigger and bigger, every Wednesday and Thursday we also give away a 500 Rand cash prize to one lucky winner. And all you have to do to win that prize is to be watching us live in order for you to claim the prize at the end of the show. Now, the riddle for week 10, and I still haven't gotten this one. Well, not quite anyway. The riddle for week 10, I think, is one that is slightly different or slightly difficult, rather, for those who probably, are trying to crack the riddle. I want to hear from you at home if you think you might know what the riddle is leading you. I know some of the other riddles have actually been quite easy over the past few weeks and have been quite easy to crack as well. And the riddle for this week, and my colleague Biola is going to put it on the screen, is: let your imagination go wild with pricing. At the bay where you'd like to camp, 6 gorgeous rooms to fit all your friends, and a flat even this Watson would take. And that is the riddle for week 10 of our Sherlock Holmes Hunt. All the best to you at home if you're going to enter this one. And for those, of course, who've already entered, fingers crossed, maybe we'll call your name this evening or perhaps tomorrow when we announce who the lucky winner is. Now, as it is a Thursday, I'm sure many of you were watching with the bated breath as the Reserve Bank Governor was announcing earlier this afternoon that the repo rate remained unchanged at 3.5%. So we're going to have prime remain at 7%. I know that many of us in the property space would have absolutely loved a bit of relief with, of course, an interest rate decrease, even if it was just for, a mere 25 basis points. And there seems to be indications that we may see a rate increase of 25 basis points in Q3 and Q4 of this year. So we will be watching that with bated breath. Every person I've had a conversation with about interest rates this evening, I've certainly said I actually wish they had decreased it by 25 basis points because we certainly do have room for, managing a rate decrease. But we'll certainly see what happens in Q3 and Q4. Hopefully they're not going to increase it as they've shown indications of potentially doing so, but at the very least that it will hold yet again. Now, of course, one of the things that you can look forward to here on Private Property, besides getting the latest in property news, and of course, as you tuned into the Private Property Podcast, absolutely exploring, a hot property topic where we get an expert who will help us navigate that particular issue. Are the other great shows that you can also watch? It's a Thursday this evening, so Umbali Noko later on at 8 p.m. will be on with the Farming Podcast, and she's on your screens every Tuesdays and Thursdays at 8 p.m. So do make sure that you tune into the Farming Podcast later on this evening. Every Monday and Friday, Chad brings you the Home Shoppers Show, and that's one that you can look forward to if you're on the market for a new property, as he, unveils amazing properties that you could potentially dip into if you're in the market. And every Wednesday, Essie Clarkson brings you the First Time Home Buyers Show, where she's always in conversation with people who've walked that path and have certainly gone on to grow their property portfolios in different ways, and be able to best learn from some of the mistakes that they've made and some of the things that they got right along their property journey. Well, this evening we are exploring something quite exciting, and I think one of those things that we always encounter in property, and sometimes many of us probably don't quite know how it relates to us, and we're revisiting Voetstoots and whether or not Voetstoots clashes with the Consumer Protection Act, and to help us better understand what Voetstoots is, how it relates to property purchases in particular, how it even relates to the Consumer Protection Act. This evening I'm joined by Mark Blanckenberg, who is an associate at Schindlers Attorneys. Mark, good evening, and thank you so much for joining us.
Evening, Zama. Thanks so much for having me.
So, Mark, I think one of the things with, Voetstoots, a lot of the times when we talk property, it's one of those things that you sometimes either you know what it is or you think you have a vague idea of what it might be. Perhaps the best place to start with our conversation is, what exactly do we mean when we talk about Voetstoots, especially as it relates to property?
Okay, sure. So Voetstoots is one of those Roman Dutch law maxims that we've inherited into our law. And essentially what it is it's a protection for your seller. Okay, so it's a protection that basically says from your seller to your purchaser that, Mr. Purchaser, you're accepting the property in the condition that it is. So in the condition that it stands and how you see it, you're accepting it in that condition. So you're accepting it with whatever defects there are on the property. Okay, so whether they be patent defects or latent defects, and let me just quickly give you a quick description on the difference between those two. A patent defect is a defect that is visible. So that is something that your purchaser, when he does an inspection of the property, and remember, guys, just when you are purchasing property, there is actually an obligation on you to inspect it. If you're going to be purchasing a property, there's actually like an understanding that you've been given an opportunity to inspect it, and you have done that reasonable inspection of it. So a patent defect is everything that can be seen. So for instance, mold on a wall that is visible, that is a patent defect that's covered by Voetstoots. The other aspect that Voetstoots does cover as well is latent defects. And a latent defect is a defect that a purchaser cannot see. So for instance, that's like a leaking roof. You can't pick up that a roof is leaking when you inspect the property. But what corresponds with that is that your seller, with the Voetstoots clause, he's only covered for the latent defects. So remember, the latent defects are the hidden ones. He's only covered with Voetstoots for the latent defects if he discloses them. So if he tells you that, look, you're buying this property, you can't see it right now, but I'm telling you that there's a leak in this roof. Your buyer doesn't have a claim against your seller later for, when it rains and that leak comes out there. But just remember that there's that obligation on your seller that he needs to disclose it. So yeah, that's basically like a summary of Voetstoots. I don't know if there's any other aspects of it you want me to touch on.
Yeah, so I think, Mark, one of the things, of course, for people who've bought property is often there is a clause in your offer to purchase around that. Perhaps take us through navigating that particular clause, because I tend to find that, oftentimes, obviously, an offer to purchase has various types of, we'll say, relatively standard clauses. And I say relatively because there are, different kinds of clauses that obviously get, inserted in an offer to purchase. And sometimes people just don't quite know how to navigate certain ones. Sometimes they just don't understand what they're signing off. Sure. I think one thing I tend to find is that when we sign an offer to purchase, 8 out of 10 times we probably don't understand the document in its entirety. You kind of just search for, where you need to initial and your name, to the point where sometimes people don't even double check that they're signing an offer to purchase to the right property. I mean, so even simple things like just checking the property details, are they the correct details, your details, obviously the seller's details. So little things like that easily get missed. And I know as you sort of go through the process, sometimes they get picked up and they get changed, but obviously not everybody's has a good understanding of then the Voetstoots clause and how it comes into an offer to purchase. Perhaps explain that particular clause to us when it comes to the offer to purchase.
Sure. So, Zama, I think just as a general principle for everybody listening is, when you sign when you sign a written agreement with a company or with a supplier or with your seller, if you're purchasing property, you are deemed to have read that entire contract and understood exactly what is said in that contract, and that is one of the principles of our law. So it's not it's very, very difficult for you to turn around at some stage and say, oh, this clause wasn't explained to me, or I didn't understand it, so it shouldn't be binding on me or anything like that. Just generally speaking, with our law, if you're going to put pen to paper on a written agreement, you're deemed to have read that whole thing and understood it. And really, that is why it is very important, I think, that when somebody is entering into an offer to purchase for property, that, generally speaking, you're doing it with an estate agent. And at that time, it may be a little bit tedious. It may not be something that's like, really grabs your attention, but you should really go through it in detail with the estate agent. Ask them the questions that you need to ask them, because that estate agent knows that contract like the back of their hand, and they'll be able to, they've got the experience in the industry, and they'll be able to give you all of those, explain the nuances and all of the things that might not exactly leap out at you from the paper. But I mean, look, I can just give you, we'll go through a basic Voetstoots clause, and just remember as well that in every single estate agent's standard offer to purchasers, there are Voetstoots clauses. A lot of people feel like Voetstoots is no longer a part of our law, but it very much is still in operation. And in just about every single property transaction that goes on in this country, Voetstoots does play a part. So basically, the Voetstoots clause, the template one that I've got here says the purchaser records that he or she understands that the property sold in terms of this offer to purchase has been offered for sale by the seller in the condition in which it stands on the date that this agreement is signed. So what that means is that when you're signing that agreement, the expectation on you as the purchaser is that you have made yourself familiar with it. You're saying that you understand that you're accepting the property in that condition that you see it in. And so that means that if it's in that same condition when transfer occurs, you have to accept it in that condition. The only time that you've got something legitimate that you can raise is if there's some kind of a latent defect that you couldn't see, that the seller did not disclose to you. Okay, so for instance, the leaking roof. And look, I don't want to overcomplicate it, but another part of it is that, remember, your seller can only make the disclosure if they are aware of the defect. So if there's a leak in the roof that's been there for like 5 years and your seller is well aware of it and he doesn't disclose it, then of course, then you do have some kind of a damages claim against your seller, or some kind of a potential to put them in breach and potentially pause the transaction until it's resolved. But if it's a latent defect that your seller could not have been aware of and couldn't have disclosed to you, then it's not something that you as the purchaser would have the claim against them. But the important thing here is that you're recording that you as the purchaser are happy with it in the condition in which it stands. If you're buying a second-hand property and it's an old property and there are things that are loose or not quite working and there's doors that don't close properly and that kind of thing, that's the kind of inspection that you need to do. You need to go and check that locks are working, check that the water pressure in the taps are working, check that a toilet is flushing. I mean, I know it might sound like you're going into serious detail, but the test is what would a reasonable purchaser do on their inspection. And, that reasonable test is, there's no black and white about it. There's a lot of gray areas. So if you're a purchaser that's doing an inspection, I would say always err on the side of caution and inspect more than what you would say, normally think, like maybe go take it to another level to try and make sure that you familiarize with the property, because you're accepting the property in the condition that it's in. Okay, so that's the first part of it. So do you want me to quickly do the second one?
Yes, please.
Okay, so the second part of the clause of the standard one is the purchaser records that she or he has had an opportunity to inspect the property. The purchaser specifically agrees to accept the property in the condition in which it stands as of the date of this agreement is signed. It's kind of redundant, aside from the first part there where it says that the purchaser has had the opportunity to inspect the property. So, of course, that should maybe make you think, okay, look, if I didn't get the opportunity to inspect, maybe we need to think about this clause more carefully. But, of course, 99% of the transactions, the purchaser does get the chance to inspect. But I think what that clause indirectly is saying is that, yes, there's a duty on the seller to disclose, but there's also a duty on the purchaser to inspect. So there's those two competing obligations and interests there.
So then, Mark, I think this then brings us to how this essentially then relates to the Consumer Protection Act, because I'm sure the now viewers who want to understand sort of that correlation with regards to what the Consumer Protection Act actually says and how it relates to purchasing Voetstoots.
Okay, so I guess what the CPA has done is it's kind of created this massive misconception in the property market, because to a lot of people, as purchasers, it sounds like a reason for every property to have to be absolutely perfect and to be like brand new. And for a lot of people, when the CPA came about, they thought, okay, this means the end of Voetstoots in our law, because with the Consumer Protection Act, somebody has to provide me, something up to my level of expectation. And I've got, of course, that cooling off period where I can potentially cancel the agreement. And we have countless times during the year, we'll have purchasers contact us telling us, number one, that they want to pull out of the agreement, they want to exercise their right in terms of the cooling off period, or that, this property is not up to spec because in terms of the CPA, it should be like a brand new property. But unfortunately, that all comes from a misconception. The Consumer Protection Act is only applicable when your seller is a supplier in terms of the Act. Okay, and a supplier in terms of the Act is somebody who sells something in the ordinary course of their business. Okay, so what that means is that really, in terms of property transactions, the only time that the CPA is applicable is actually when you are buying directly from a developer, where somebody is selling you a property and they're selling it to you in the ordinary course of their business. That's really the only times that the CPA will apply. Zama, if you are selling your house to me, you don't sell property as your profession. It's not your stock and trade. It's not what you do in your day-to-day business. It's just that you are selling your house and you're moving on to another spot. The CPA does not govern an agreement of sale between yourself and me. It's actually not applicable at all. And so really, I mean, that's the actual legal position, and that's why Voetstoots is still very much applicable and very much a part of our residential property situation. But the misconception with a lot of people is that the CPA is applicable to all transactions. It doesn't matter what they're buying, they're protected by the CPA. But in actual fact, it's only when you're buying something from somebody who's doing it in the ordinary course of their business. So what that means is that 99% of the time with normal resale and residential property, the CPA is not applicable at all. And Voetstoots is really what governs how it's managed.
I am this evening in conversation with Mark Blackenberg, who is an associate at Schindlers attorney, and we're revisiting Voetstoots and whether or not it clashes with the Consumer Protection Act, and better understanding, what Voetstoots is, how it relates to us, especially when we are buying property. We are taking your questions and comments on our social media platforms. We've got a question here coming from Facebook. Ulerato Liu asking, what suggestions will you give when purchasing Voetstoots? And I think you already started giving them earlier, Mark. So what suggestions then do you give to our buyers when it comes to this? And I'll say even sellers, because, as you're saying, a lot of the viewers at home also are, property investors. So they've got rental units. And the reality of a rental unit is you don't always know what is right or wrong in the property because you don't, live there. Whereas with property that you live in, you might know of that leak, every summer it kind of happens. But unfortunately with rental property, sometimes perhaps your tenants don't tell you about what could potentially be wrong with it. They kind of stay there. And by the time they move, they don't give you a heads up because they think you might want them to pay for that particular defect. So what suggestions would you give, I'll say then, to both parties when it comes to this?
Sure. So, Loretta, when you're purchasing a property, Voetstoots, and remember that generally speaking, it is going to be Voetstoots. Unless you are purchasing the property from a developer, then you will be purchasing it with Voetstoots. And really, the most important thing to remember there is that there's the obligation on you to inspect the property. When you're purchasing, you're accepting the property in that condition in which it stands. So, like I said earlier, I think just, whatever you think you would generally do as a baseline for inspection, take it a little bit further, make sure that you make yourself as aware with the property as you possibly can be, because, and look, I mean, it's it's not exactly an exact science. You're always going to move into the property and at some stage find out something about it that you didn't realize while you were doing the inspection. But I think the more thorough that you do your inspection, the less surprises you're going to have. But that would really, I guess when you're purchasing, that would really be the main thing, is that there's the duty on you to inspect, and you must go through it with as much detail as possible. Then with the sellers, I guess the important thing with the seller is the disclosure document, really. So you do not need to disclose to somebody that there's a broken window or that there's a giant mold infestation in one corner of the property or something like that. If there's something that is patent, if it's something that's visible to the naked eye, you as the seller, you don't need to make a disclosure there. Where you do have to have your thinking cap on is what is it that you're aware of on the property that a purchaser would not be able to see? And of course, the most common one is the leaking roof. If you're aware of some kind of a defect like that, you need to disclose it. If you're not aware of a defect like that, and like you said, Zama, if it's a rental property that you don't live in, or we often have it with an estate late. Somebody has been living in a property for 30 years, they pass away. Now the executrix or the executor of the estate needs to sign the disclosure document. It's a very, very difficult thing for them to do because they don't live in the property. How they're supposed to do that competently, but they generally just have to do the best they can and just make the best disclosure that they can. You can't disclose about a defect that you're not aware of, but you do need to just make whatever the best disclosure is that you can do. And the other thing in terms of the property practitioners bill is that, and I can't remember when it's going to be applicable, I think it's towards the end of the year, but every single transaction is going to need to have a written disclosure document filled out, which is going to lead to some complexities, because at the moment we sometimes have to do properties without a disclosure document, just like that instance where somebody's been living in the property, has now passed away, nobody really knows the condition. The executor, is somebody at the bank. They're not going to go through to the property and go check all the taps and go check that everything closes and all of that kind of stuff. So how exactly are we going to do written disclosure documents on property sales when there isn't practically somebody who actually knows the property? But I think, that's really the most important thing, is just as the purchaser, you need to know that you've got that duty to inspect because you're accepting it in the condition that it is. And as the seller, any kind of a latent or hidden defect, you need to make sure that if you're aware of it, you are disclosing it. And, the important thing I think is, as a seller, is when you fill out that disclosure document, it's one of the most important parts of your sale, because if you are dishonest on it, or you're just a bit lost-scope when you do it and you forget to fill something out, it can really come back to bite you. If your seller says, look, Mr. Whoever, you said that there were definitely building plans for this property. Now there aren't any building plans. You've made this material misrepresentation, and now you can be liable for damages or potentially lose your sale.
Mm-hmm. We are taking more of your questions and comments on our social media platforms this evening. We've got a comment coming from Facebook, Angelique Groenewald, saying your live channel is full of information that a lot of potential new homeowners might not be aware of private property. I'm like a sponge right now. Thank you very much there, Angelique. I'm glad that you're enjoying the live podcasts. And we've got a question here coming from, and I love this question. It's coming from Rose Ntwane, who says, wow, this is so informative. Is there a time frame in which I make against the seller for non-disclosure of defects on the property that have been intentionally hidden or temporarily mended or fixed?
So in terms of our common law, there's a 3-year period. So in terms of the common law, it's 3 years from the date of sale that the seller remains liable for latent defects. But generally speaking, what you would need to do is, as soon as you're aware of it, you need to bring it up. And of course, there's 2 different instances here. There's the instance where you find it before transfer happens. So you've entered into your agreement of sale. You become aware of a latent defect before registration, and then you would be able to raise it, and potentially you would be able to halt the transfer process until it was resolved, or negotiate some kind of arrangement to go forward, or potentially if the latent defect was serious enough, you would also be able to put your seller in breach and thereafter cancel the agreement and walk away from the transaction if they don't remedy that breach. So that's the first instance, when you find out about those latent defects before. And then the second one would be after registration of transfer. And so, look, I mean, I think the longer that time elapses, the more difficult it's going to be for you to enforce your claim, just from a practical sense. So if you find something out 2.5 years later, the difficulty for you as a purchaser is that you need to prove that your seller was aware of this defect and intentionally withheld that information. So if you only found out about it 2.5 years after purchasing the property, then how are you going to prove that your seller must have known? If it took you 2.5 years to realize that there was this issue and they had lived in the property for 5 years, then, potentially there's a defense that they can raise to say, look, it took you so long to discover it. We weren't aware of it, so how could we disclose it to you? You need to be able to prove that they were aware of it and intentionally withheld that information. So, conversely, if you move in and you discover this defect within like a week of moving in, then it's very, very difficult for them to say that they weren't aware of it if it's something that has clearly been there for a while. So, I mean, obviously each case is slightly different, but I would say as a rule of thumb, the earlier that you discover that thing and start raising it as an issue, the better. But in our common law, they're liable for 3 years after transfer.
We've got a great question here coming from Facebook. Mishka Jalim asking, what happens if the unit rented has defects that have not been disclosed prior to the leasee during the viewing and when the lease is provided to the tenant? These issues have only been identified on the day of occupation. Can the tenant cancel the lease immediately?
Okay, so remember that with a rental agreement, there is an ingoing inspection that needs to be done prior to that person moving in. So when that ingoing inspection is done, what is supposed to happen is that the ingoing inspection is supposed to be done with the tenant prior to them moving into the property. So you shouldn't have an instance where you move in and you discover something else that's there and that wasn't there when you did the ingoing inspection. Generally speaking, you do the ingoing inspection like a day or two before moving in. And if you find something during that ingoing inspection that you are, as the tenant, are absolutely not happy with, if it's something that's material to the property, then you need to make it clear and put it in your lease agreement that it is something that needs to be fixed by the landlord. Because remember, guys, I think also one of the big misconceptions with lease agreements is that the tenant looks at does the ingoing inspection form and says, this wall is chipped, this wall is that, and that is actually just a record of what the condition of the property is. If you want something to be repaired, it's not enough for you to just record what the condition is. You need to say that this needs to be repaired, and that needs to be agreed to with your landlord. So, if you were to do your ingoing inspection and then for some or other reason you move in on day one and there's some massive issue at the property that you didn't pick up during the ingoing inspection, then I think that you can't just summarily cancel the lease, but you would need to address it with the landlord. And if they weren't willing to deal with it, then put them in breach in terms of the agreement and then cancel it. So remember that also there isn't a provision in these agreements, and it's for offers to purchase and for lease agreements. You can't just summarily cancel an agreement. There is a breach clause in both of those things, which sets out the procedure that you're going to follow if you want to cancel. So you're going to send somebody a letter of demand. You're going to give them 7 days or 10 days, whatever the period is, which allows them to remedy that breach. If you were to move in and, okay, you realize that there's, your landlord hasn't paid the bill or whatever, and there's no running water to the property, you would place them in breach. And if they don't remedy within the week, then you would cancel the agreement.
Now, Mark, before we wrap up, any final tips for our viewers at home when it comes to, best understanding Voetstoots, especially when we are buying property?
Oh, final thoughts. I mean, I feel like I've exhausted everything I've got. I don't know. I mean, I guess what the important thing is that I think a lot of people dismiss the advice that they get from estate agents on what to do with inspecting the property or making disclosures on the property. Like generally speaking, if you're working with an estate agent, like lean into the fact that they are a property professional. They work in they work in property 24/7, and they probably know a lot more than you do about that industry, because that's what they work in. So I would say, like, take their advice on the Voetstoots and ask them the questions on the agreement when you have them there going through it. Don't gloss over it. Go through it in as much detail as you can. Especially because when you're buying property, it is invariably an expensive purchase, and it's a purchase that is potentially going to be your biggest monthly installment, every month for the next 20 years or whatever it's going to be. So take your time with it and don't try and rush through it, I guess.
Well, that's a great place to leave it there, Mark. Thank you so much for joining us.
Pleasure. Thanks so much for having me, Zama.
And that is Mark Blackenberg, who is an associate at Schindlers Attorneys. It is, of course, a Thursday, so we're going to go for a quick break. And when we come back, we will be announcing the lucky winner of that 500 Rand cash prize. Remember to stay on the live, because if we call your name, we want to make sure that you are, in fact, watching us. We'll be back just after this. Welcome back to episode 227 of the Private Property Podcast. I'm your host, Uzamantomwa Khumalo. Well, it's that time of the evening where we get to give away 500 Rand in cash. If we call out your name, then do give us a shout down here below in order for you to claim your prize. And the potential winner this week, or this evening rather, goes to Dawn Govender. Dawn Govender, I'm going to give you a minute or two to just drop us a message down here below. So Dawn Governor is a potential winner of that 500 Rand in cash. And all Dawn has to do is to drop us a message down here below to let us know she is, in fact, watching us live. And of course, if you want to be just like Dawn, all you have to do is to enter the Sherlock Holmes competition on our website. That's www.privateproperty.co.za, and follow where the riddle leads you. And if you answer correctly, you stand a chance of not only potentially walking away with the 500 Rand in cash, but you also can walk away with the 5,000 Rand voucher that we give away every single Friday. And as we draw to an end of the Sherlock Holmes competition, and we're on week 10, and of course there are 2 more weeks to go, there will be a grand prize that we're going to be giving away. We're still keeping it hush-hush for now, so do enter that competition as many times as you would like. So Dawn Govender is the potential winner of that 500 Rand cash prize. I'm just waiting for my colleague to let me know whether Dawn is in fact on the live, or we're going to have to go to our next person on the list who may potentially be walking away with that 500 Rand in cash. And of course, we are also getting ready for our 1-year anniversary that we're going to be celebrating next week, Wednesday. Remember, we had that first episode of the Private Property Podcast with Uzak Mieza and Gil Sperlin on the 30th of March last year. We were deep into lockdown. We were just a couple of days into lockdown, and we wanted to talk about landlords and tenants and how we should, almost go about navigating the relationship together. And I see that Dawn is not in the house, and so the prize, the potential winner, is now going to go to Bass Queen Aki Makumza. That is Bass Queen Aki Makubza. If you are on the live, then please drop us a message down here below. You may potentially be walking away with that 500 Rand in cash. That's Bass Queen Aki Makubza, who is potentially going to walk away with that 500 Rand in cash. Remember, the only way you can win the 500 Rands is you have to be watching us live so that you're able to claim your prize. That's the only way you get to walk away with the cash. So do make sure that every Wednesdays and Thursdays you watch the show live, especially if you know that you've entered the Sherlock Holmes competition. So Bass Queen Akima Kubza, we're going to wait for you to see if you are on the live and can claim that prize. As I was saying, next week Tuesday, we get to celebrate 1 year of the Private Property Podcast. We've certainly brought you quite a number of episodes. Over 200 episodes have been brought to your screens. We've covered a whole host of topics, and of course, going to continue bringing you the best in all things property. And we want to know how you want to see us celebrate that 1 year anniversary. We obviously want to do it in style as much as we can and still bring you what you love seeing most, which is, of course, great property issues with amazing experts who help us navigate our journey. So do let us know what your thoughts are on that one. And I see Bass Queen is also not online this evening. We're going to give it one more try with the next potential winner. And the next potential winner is Khutso Ramohlale. Khutso Ramohlale, if you are on the live, then do drop us a message down here below and you can claim that 500 Rand in cash. That is Khutso Ramohlale, who is potentially going to walk away with that 500 Rand in cash. Remember, if we don't get anybody who is watching the live that we have called, we're going to roll it over next week. And I see, because, the first time we're going to have to do the giveaway will be on Wednesday. Maybe I'll be spicy and we'll do a nice giveaway also for the 1 year anniversary show. So the rollover, of course, is always 1,000 Rands for the following day, but for the following week in this instance. But we'll see if Khutso Ramohlale is on the live, and if they are, then they get to walk away with that 500 Rand in cash. And I remember, we certainly love hearing from you here on Private Property. We want to hear how you would like to see that 1 year anniversary show come together next week, Tuesday. The team and I are planning what we can do and how we can make it extra special for you at home. So do let us know what you would love to see on your screens as we celebrate 1 year of the Private Property Podcast. It's almost like you're raising a baby. So they're now at that age where they have a few words, they've gotten acquainted with certain things, they're able to understand certain things. And over the past 12 months, we've certainly grown as a show and also grown with you as our viewers at home. And we certainly do love to see the growth. We love it when you invite more of your friends and family to the live to watch us, of course. And as I always say, to make the property circle bigger. And of course, we are waiting. Khutso is in fact on the live. And unfortunately, Khutso is not on the live. Then we're going to have to roll it over to next week, where the lucky winner next week is going to walk away with 1,000 Rands in cash. So Khutso, I'm just waiting for my colleagues to let me know if you are in fact on the live. And if not, then I think whoever's going to win next week, well, you're going to be, doubling it up. And we see that she's saying Khutso is not giving us a sign. So unfortunately, Khutso is not on the live. Well, that means that next week we are going to double it up and we will be giving away 1,000 Rands in cash. And that certainly is it from myself, Zamantungwa Khumalo, and the rest of the team behind the scenes this evening. We're going to be bringing you, as it is a Thursday, this evening's episode of the Farming Podcast with Umbali Noko coming up in just a bit. And as usual, hoping you're staying home and staying safe.